All right, all right. Hey everyone, Boss Attorney Bri here. If you are new to my channel, go ahead and comment in the chat. For those of you who do not know who I am Boss Attorney Bri. I am a trademark and business attorney in California. So today we have a couple of cases to go over. There was a lot going on over the weekend, so we have a good amount of cases to go over that are right up my alley, including breach of contract, trademark law, and copyright law, all happened last week or within the last week or so. So we're going to be going over that today. If you are new to the live stream, be sure to go ahead and drop where you're from and let me know who you are. And also let me know if you guys have a YouTube channel because I am new to streaming. And so this is always very nerve wracking since every time I go live. So let me know where you guys are from, and we're gonna jump right into the cases that I have for today. So, sorry guys, trying to get my stuff together here. Okay, so we're gonna jump right into the cases that we have for today, and like I said, it's covering all things business law, but it has to do with celebrities. So the first thing that we're going to talk about is Selena Gomez and her trademark infringement lawsuit, where it's actually a declaratory judgment that she filed against a smaller cosmetic line, and it's for her Rare Beauty cosmetic line. We're also going to be going over Chris Brown and Drake's dismissal of the copyright claim that the writer of a song called I Love Your Dress filed against them late last year, in October of last year, saying that No Guidance copied their song. So we're going to go over that case. And we're also going to be going over Floyd Mayweather's second case of the year. If you have watched my channel before, you will know that he was actually named as a defendant in a cryptocurrency scam lawsuit like January 7th of 2022. And now he has this breach of contract lawsuit filed against him as of January 31st, 2022. So he got served, or I don't know if he's been served yet, but there has been two lawsuits filed against Floyd Mayweather within the last 3 or 4 weeks. So he's having an interesting start to his 2022. But we're going to get into that case a little later. I want to go ahead and start with Selena Gomez and the beauty trademark infringement suit that she has going on. And we're covering this because it is affecting a small Black business. And I want to go over it and talk about what standing Selena Gomez may have and what standing the small Black business owner may have. So I'm going to hop right into it. No reason to delay. If you are watching on live, go ahead and let me know where you're from. And if you are watching on the replay, make sure to drop a comment down on where you're from. Also, do not forget to like this live stream to help it out in the algorithm. And I am just going to pop right over to sharing my screen. 1 second. I still am not that great at getting things together here. So let's see. All right. Oh, wrong one. All right. So we are sharing the screen and we're talking about Selena Gomez. So I'm going to first start off with this article. It's talking about how Rare Beauty, which is owned by Selena Gomez. If you don't know who Selena Gomez is, she is an actor, a singer. She came from Disney Channel, if I'm not mistaken. I used to watch her on Disney Channel for The Wizards of Waverly Place, and she had some small roles in some other shows, and I'm not quite sure what else movies she does, but I watched her on Disney Channel growing up. So she owns Rare Beauty, which is a cosmetic line that she launched in 2021. And so we're going to go on down to this here tweet. I think it's a tweet or Instagram post, actually. It's an Instagram post of this young lady named Kashina Hurd. She is the owner of Rare Beauty Cosmetics. And what's basically happening is that she is upset that she's not able to get her trademark filed because Selena Gomez's trademark actually conflicts with her trademark. So the way that trademark law works in the United States, you cannot register a trademark that is the same or confusingly similar to someone else's trademark that is already registered, has been applied for, or that is in existence in general. But when you're filing a trademark, the only trademarks that the USPTO looks at, unless it's like a super common name, are the ones that are on their database. So technically, if you don't file it, it's very easy for someone to miss your trademark. And so that's what's going on here. Selena Gomez filed what's called an intent to use trademark back in 2017, November of 2017. And then but Kashina, the owner of Rare Beauty, the smaller business, she actually, one second, I'm struggle streaming here. All right, so she filed her she didn't file a trademark, but she says that she started her business back in 2017. I believe it's April of 2017, as we'll go through the complaint that Selena Gomez filed. And so she said that during this time, she looked at the USPTO and she either didn't see Selena Gomez's trademark or she didn't think that it conflicted with her. The issue that I see with her search that she did of the trademark database is that she probably did not do a proper search. She should have hired an attorney to do her search, because let's go back over, pop out the screen. All right, let's go back over. She actually has her name as Rare Beauty, but it's all one word. So it's like Rare right next to Beauty, while Selena Gomez's is just Rare space Beauty. And Selena Gomez went ahead and filed her trademark through her legal team, as she should have, for an intent to use application, because that will protect her, even though what an intent to use application is that you're not necessarily using the trademark quite yet, but you intend to use it in the near future. So Selena Gomez made the right move and went ahead and filed an intent to use application. So we have this article saying that Ms. Heard made multiple claims against the Gomez brand, include priority and likelihood of confusion. So basically what happened is when this Ms. Heard, Kashina, the small business, went to try to register her trademark, she found Selena Gomez's, and then she filed what's called a petition to cancel Selena Gomez's trademark, so that basically she can go and file and have her trademark for Rare Beauty Cosmetics. But she cannot file it because an attorney probably advised her and let her know that if you file this, it will get rejected because this big brand is already owning it. And of course, she found out it was Selena Gomez's brand and went ahead and filed a petition to cancellation. They are still in those proceedings, which is a bit, not too crazy, but a little different, that they're going ahead and filing this declaratory judgment against Kashina, because the cancellation proceeding is still going forward. And what's happening is Selena Gomez is basically trying to stop this before it goes any further, so that the USPTO, which is the government entity that decides whether or not you can have a trademark, she wants them to go ahead and decide that there is no confusion, there is no issues with the trademark, and so that they should go ahead and dismiss this claim to cancel the petition, because Selena Gomez not only has this trademark, but she has various other trademarks that are under the Rare Beauty, and they have like different names to it, like certain cosmetics are on there as well, and they're also under Rare Beauty. So of course they do not want to lose their trademark. They have 2.9 million followers on Instagram, and the brand is apparently doing very well, which we will see in this here complaint. All right, I did not want to do that. Okay, here we are. All right, so let's go ahead and pop over to the complaint so we can see exactly what Selena Gomez and her attorneys are asserting. As you can see, the names are pretty similar. This is Selena Gomez, Rare Beauty LLC, and this is the small business owner, Kashina Heard's Rare Beauty Cosmetics LLC. And it is filed in the Northern District of Illinois, because that is where Kashina actually operates her business. And as you can see, this is actually a declaratory judgment, which is basically saying, like, we don't want to go through a whole lawsuit and a whole trial. I want you, judge, to decide that this lady has no case and that you guys should go ahead and just cancel, let her know that her trademark, we're not confusingly similar, and that she should not be able to cancel our trademark so that we can give it to the USPTO, and this case can basically be over. So they're not asking to have a full trial. They're asking for a declaratory judgment, okay? And so, of course, they're the plaintiff and the defendant. And I'm just going to start off with the nature of the action. Rare Beauty, Selena Gomez's company, seeks a declaratory judgment that it is not infringing any rights that the defendant might have in Rare Beauty, the trademark. Such relief is necessary because defendant has wrongfully and affirmatively accused Rare Beauty of trademark infringement and dilution, filed a petition to cancel Rare Beauty's U.S. trademark registration for the Rare Beauty mark, and threatened to sue Rare Beauty for alleged trademark infringement unless Rare Beauty gives the defendant $10 million. So this small business owner is basically asking for Selena Gomez's company to give her $10 million or cancel their trademark, or she's going to file a lawsuit against them for trademark infringement. And so doing this, I cannot say this word today, declaratory judgment against her can do a couple of things. So it may stop Ms. Kashina Hurd from going ahead and pursuing this, because federal lawsuits are very expensive, or it can stop the cancellation process from going forward, because that can also be more expensive or very expensive. But the cancellation process is not actually through a court, it's through the Trademark Office Trials and Appeals Board. So it can easily be more cheap, or it can be cheaper to go ahead and do it that way versus filing a lawsuit, which is why Kashina probably filed it this way to begin with. And Selena Gomez's company is just kind of like, okay, if you want to do that, then we're going to go ahead and do a lawsuit. They go ahead and let us know who the parties are, where they're located. Like I said, Ms. Kashina is located in Illinois, and that's why this lawsuit is filed in Illinois, and it's a federal case, so that is why it is in the district courts rather than a state court. And let's just get into, and let me just pop over actually, because I can't see anything going on. All right, I see there are some people in the chat, so go ahead and let me know where you guys are from. And don't forget to like this video. I am going to pop back over on my screen to the complaint. I know you guys can still see it though. Okay, so into the background of this case. Rare Beauty is a mission-driven beauty brand. So we're not going to go all through that, because they're just saying that they're a beauty brand that people know about, and they are inclusive, basically. And so since at least 2016, Rare Beauty and its predecessors of interest have invested a substantial amount of time, money, and effort to develop, secure, promote, and advertise cosmetics under this name, Rare Beauty. Following the years of development, Rare Beauty launched on February 4th, 2020. And so this is the biggest part of Ms. Kashina's argument, saying that the only way that they can have a trademark is if they are actually using the trademark, which is partially true. But if you file an intent to use application, like Selena Gomez's company did, you get priority in that name all the way back to the day that you filed. So if you come up with a business name and you know it's super unique and you want to use it and you know someone might steal it, hence Selena being a celebrity and knowing that people might want to steal her name, she went ahead and filed an intent to use application. So even though she did not launch until 2020, she actually filed in 2017. Giving her rights all the way back to 2017, even though she technically was not using it in commerce yet. That's the whole point of the intent to use application. And I'm just not sure if Kashina's attorney is just not telling her this, or if Kashina just doesn't want to hear it, because Selena Gomez has priority back into 2017. It doesn't matter if she was actually selling stuff, because she filed an intent to use application. And so it's going to be really hard for this Ms. Kashina to prove that she actually has priority in the mark, okay? And so Following the years of development, Rare Beauty launched to February 4th, 2020, and has 100 or had 100. They posted and reached 168 million followers between February 2020 and August 2020. So they're basically saying like people know about this brand. They've already associated our brand with Selena Gomez under Rare Beauty Cosmetics. They're not thinking of Miss Kashina's brand when they're thinking of Rare Beauty. On October 3rd, 2020, Rare Beauty began offering the sale of its first line of beauty products, and they have 150 different products at the time of this whole lawsuit, including lipsticks, liquid blush, eyeliner, brow pencils, and a diverse range of foundations and concealers and other related products. Since then, Rare Beauty has enjoyed enormous success, generating millions. So they're letting them know they've made millions under this name already. Basically, we shouldn't have to change our name because our business is already doing very well under this name. And they have 2.9 million followers on Instagram. People know us under this name, is basically what they're trying to say. And so in August 2016, Rare Beauty, through its predecessors of interest, which basically means just a company. Maybe there was a company that wanted to create this brand, and then they sought out to Selena Gomez to see if she wanted to invest in it, and then Selena Gomez became the owner of the company. That's just what the predecessor in interest is. It's just someone started the company, and then they gave the rights to Rare Beauty LLC, that is Selena Gomez's company. And I keep distinguishing it's Selena Gomez's company because the other company is also called Rare Beauty Cosmetics, and it can get pretty confusing, which is why Miss Kashina is trying to get the name back from Selena Gomez. And in the article that I showed you guys a little earlier, she in her post, she's like, she's a small Black business, and basically that Selena Gomez should not be able to kind of step on her because she is a small Black business, and they shouldn't be taking the name away from her. I don't I don't really agree with that argument just because she did not file her trademark. And this is why I always stress to my small business owner clients that if you really want a name and you really love it and you want to make sure that you can own that name, then you need to file your trademark even if you have not started selling things yet, which is what Selena Gomez did. Miss Kashina, if she started in 2017, she should have filed an in-use application in 2017, in April 2017, which she is saying that's when she started her business. And then she wouldn't have these issues because Selena Gomez didn't file until November 2017. So that's all I'm saying. If she would have did her due diligence and filed her trademark, she would not be in this situation. So if you are a business owner and you don't know about trademarks, make sure you talk to a trademark attorney. I happen to be one, so feel free to book a call with me if you have any questions about your trademark situation. Alrighty, so I forgot where I left off at. 2016, Rare Beauty, through its predecessors of interest, prepared to use the Rare Beauty mark in connection with the cosmetics, including conceptualizing the product and working with manufacturers. In March 2017, conducting a trademark clearance search, which is the thing that Kashina did not do, or she did, but without an attorney. The trademark clearance search disclosed no prior trademark registrations or uses of Rare Beauty in connection with cosmetics. So, like I said just a moment ago, if Kashina would have went ahead when she started her business, would have went ahead and filed her trademark application, then Selena Gomez's company would have found her, and then they would not have filed the trademark, or they would have tried to pay her off to get the trademark for themselves, and she wouldn't have this issue. And so I kind of pop back over to my screen, and we have Adara. I hope I'm saying that right. Hello, welcome to my live stream. I hope you're doing well. And looks like Selena is going to win, unfortunately. You are seeing this, and I haven't even got like through the complaint yet because they have a lot of arguments. And like I said, I'm not sure if Miss Kashina's attorneys are just not telling her this is how stuff works or this is how it doesn't work. But for some reason, she's not catching the hint and thinks just because she was selling things in 2017, then she automatically wins. But that's not how it works. You have to show priority. And Selena Gomez secured her priority by filing an intent to use trademark, which gave her the time to develop her product until she was ready to launch. So it gives the priority back into the date. So let's pop back over to the share screen. I'm kind of getting the hang of the pop back over here. I'm pretty proud of myself at this point. For those of you that don't know, I'm new to live streaming, so I get a little excited when I can make the screens go back and forth without too many issues here. So let's go back. All right. So yeah, so they started selling under Rare Beauty in November 2017. They filed the intent to use application. And so they're filed with the USPTO. Here's their serial number of their application, and that it was ultimately approved by December 15th of 2020. And they went ahead and showed the court, like, hey, this is our registration. You can look it up on the USPTO. We're not lying. Then they go on to say, and we also have these associated trademarks under the name or a similar name. So we have this Rare Beauty for the retail store, which is related to selling the products, because I think they sell online. Their Rare Beauty company online. And then they also have Rare Beauty Discovery, which is for more cosmetics, and Rare Beauty True to Myself, more cosmetics. And again, they have more trademarks under related names for Rare. They're trying to make sure they have the monopoly on this name in trademarks for cosmetics, because that's what you're supposed to do when you're really serious about pushing your products under your name. You don't want somebody coming and copying you just by taking just a small portion of your name. So they're covering their bases. They're also registering Rare for cosmetics, and also Rare Beauty kind of words for lipsticks. So I guess that's one of their specific lipsticks that they are marketing. And so I'm not too familiar with the brand, because I didn't even know she had a beauty brand until this came out. But her being a celebrity, of course, someone's going to throw her name out there so that they can get a little bit of publicity for their own company, right? So since 2017, Rare Beauty and its predecessors have invested in a substantial amount of time, money, effort building the goodwill and customer recognition in Rare Beauty, such that consumers have come to identify Rare Beauty as designating the source of the rare beauty goods and services. So they're basically trying to establish that they have made that connection with their trademark and being the owner of that trademark, which is one of the elements of having a trademark. You must be using your trademark in commerce, and then people will become associate you with being the owner of the mark. Like, you think Apple products, iPhones belong to Apple. You see an iWatch. Do they call it an iWatch or they call it an Apple Watch? Whatever. That belongs to Apple. All of their products belong to them. They do it by their trade dress. So all that white, sleek look, we know it's Apple just by looking at things. Sometimes it doesn't even need the logo on it. So that's basically what they're emphasizing right there. They're saying that Kashina Hurd is the only owner of the Rare Beauty Cosmetics, the defendant, and that they believe that she launched a Facebook page under Rare Beauty. And as you can see right here, the name is connected. So it's a little bit different. And if you search this on a trademark database, it's not likely to pop up Selena Gomez's trademark, because when you do a trademark search, you have to do variations of your name. So just because you put it all together doesn't mean that it's not the same as someone that used the words individually. So that's probably the issue that she ran across, is that she did not do a search of the variation of the word, and her attorney probably found this. But when she was searching, she didn't see anything that conflicted with her. So definitely, when you're searching the trademark database, you need to be careful. And if you don't know what you're doing, just call an attorney. So she launched the Facebook page on April 4th of 2017. So again, she would have been technically using it before Selena Gomez filed her intent to use trademark application. So if she would have filed her application, she would probably be the owner of the name. since at least as early as November 20th, 2017, Ms. Heard has both actual and constructive knowledge that Rare Beauty is trademarked, basically. Since at least as early as April 2017, on information and belief, Ms. Heard considered filing a trademark application for the Rare Beauty Cosmetics and consistently monitored the USPTO's trademark system. So they're saying she should have had notice because she said herself that she had looked at the database and she didn't see anything, and she continued to monitor it instead of just filing. She just monitored it. She should have just filed. You're wasting your time just making sure no one steals your name. Just go ahead and file it. And for those of you that are not too familiar with trademarks and how much they cost, when you're hiring an attorney, it's going to cost a lot more. You're looking into the thousands and thousands of dollars. But if you are filing on your own, it can be as cheap as $250. Mind you, you might mess your application up and that can be an issue for you. But if you literally cannot afford an attorney, but you just kind of want to get your name registered, then you can save up $250 and get it filed. It shouldn't have took her 3 years to save $250 to file her trademark. If she didn't think, she did her search and she didn't see any conflicts with it, she should have just went ahead and filed. Go ahead and comment in the comment section if you would have went ahead and filed, or if you think that she's in the right. Do you think that Selena Gomez stole the name from her? I would like to know what you guys think on the situation. And of course, I'm going to continue to go through the complaint. And this is a new case. It was just filed a couple of days ago. So of course, there's no decision on it, but I would love to know what you guys actually think on the case. So let me pop back over to this here. Oh, I did not know I could do that. That is interesting. I was only doing this one, but that makes it small for you guys, huh? Okay, sorry. Um, I'm getting excited about figuring out this StreamYard situation over here. All right, so she's a corporate entity. She went ahead and filed her LLC, or her, I think she's an LLC. Yeah, so she went ahead and filed it May 9th of 2018. Again, she's saying that she started using this name in 2017, but she didn't file her LLC into 2018, which is okay because you can operate as a sole proprietorship until you're ready to turn into an LLC. So I'm not shading her for that one, but the trademark situation, she should have went ahead and filed it, and she could have just transferred ownership from herself over to her LLC when it was time, and herself as an individual would have been considered her predecessor in interest, just like Selena Gomez had a predecessor in interest. Okay. Despite monitoring the USPTO website and having both actual and constructive knowledge of Rare Beauty's intent to use Rare Beauty in connection with the products and services, since 2017, neither Ms. Heard nor defendant being her LLC, opposed the trademark application. So when you file for a trademark before it is actually registered, the people of the public have 30 days to oppose the trademark before it's actually registered. Of course, you have to be paying attention to, it's called the official gazette. You have to be paying attention to see when these names are published. So you should hire an attorney to monitor that for you. When they publish it to the official gazette, people have 30 days to oppose the trademark. So usually, if you have an attorney that's searching the database on a regular basis and they see one come up that may get registered, they can either seek to cancel the trademark while it's still in the application process, or once it's published to the official gazette, they can oppose the trademark, which can stop the registration, and you go to the trademark trial and appeals board from that moment on, and your trademark never gets registered. In this case, Selena Gomez's trademark did get registered, so puts her in a bad position at this point. All right, so it was published in 2019. She didn't oppose it. Upon information and belief, the earliest date the defendant used Rare Beauty Cosmetics in interstate commerce was sometime in 2018. They're basically saying that she started the Facebook in 2017, but she did not actually start using the trademark, or i.e. selling things under the trademark until 2018. And I think that they are basing this off of the fact that she waited to start her LLC, which does not necessarily make it true. She could have been selling things as a sole proprietorship, as I said before, or she could have had a website before 2018. They don't know, right? Until she submits information about her business. And then from information and belief, August 2020, Ms. Heard filed a voluntary Chapter 7 bankruptcy and claimed she had no assets. They did not need to throw her bankruptcy out there like that. Like, okay. Her as a sole proprietorship or as her individual self has nothing to do with her LLC, especially if it was filed in 2020. Her LLC will be considered separate from herself as an individual, but she does have an interest in the LLC. So they could be putting her out there as a liar. I don't know how bankruptcies work. So she could be in the clear for doing that, but maybe they're trying to shade her in some way for doing that too. I don't know. After nearly 4 years of actual and constructive knowledge, Rare Beauty by defendant and its founders, defendant filed a petition to cancel the trademark registration, which is that proceeding that I talked about earlier that is still going on with the USPTO. The stage that is at now in December, I think like December 16th of 2021, they asked for an extension to start the process. And so they would have 60 days to continue with that trial. The appeals trial, the Trademark Office Appeals and Trial Board, they'll have 60 days. So in 60 days, they have to go back from December 16th. So that would be what, February 16th? So this month, they should be having a response with the USPTO on that case. And so they filed, this is a separate case, it's actually with the district court, the judicial system, rather than the USPTO, which is an independent government entity that handles trademark registration. She didn't file the petition to cancel until September 2021, so it's 4 years later. And for the grounds for cancellation, defendant has claimed priority and the likelihood of confusion, dilution by blurring, deceptiveness, fraud of the USPTO, and common law infringement. Rare Beauty states that they have priority over the Rare Beauty mark. The reason why they're claiming priority is because in the United States, the way that common law trademark works, and when I'm saying common law, these are just like the rules that are made through the court cases. They're not like statutory requirements that are written into law, but you can use it as case law, basically. And so they're claiming priority because in order to have a trademark, you must be the first person to use it, and there must not be someone using the same or a similar name in connection with the same or similar goods or services that you are using them for. And so what Kashina is arguing here is that she sorry, I don't know what I'm doing here. All right, so we got Alpha saying, if you snooze, you lose. You are absolutely right about that. With trademark, so if you're the first one to use it, you are ding, 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 the winner, right? But now that they have the trademark office, sometimes the first to file gives you a little bit more priority. So she went ahead and started using the trademark. Let's say she actually did start selling things and putting products out there in 2017. Then Selena Gomez went ahead and filed their trademark in November 2017. If she would have filed her trademark in April 2017, like she said she started her business then she would not be in this predicament. However, if she waited and then tried to cancel it, let's say in 2018, she would still be in the same predicament because Selena Gomez was the first to file. And usually to show priority, you can't just be using it 4 months before the other person. For common law rights, you need to show a substantial use to where someone of Selena Gomez's standard, not necessarily of her standard, but to where someone could have found you. So I would say to at least have a year of use before you start trying to claim priority over someone that started using the trademark during the same year as you. So she's going to have a very difficult time showing that she actually has priority over the trademark. So I don't know what y'all think about that, but under the law, the priority ground is looking a little shaky for her. I would be very, very surprised if her attorney is able to prove priority. And I also think that it was a slick move of Selena Gomez's attorney to go ahead and file this district court case because 9 times out of 10, Miss Kashina's attorney does not practice in actual court. They might do trials and appeal board, which is completely different than actually practicing in a judicial court. So Kashina might be on the run trying to find another attorney that can actually help her in the federal court. So I don't know if her attorney actually does, but it may have been a slick move on Selena Gomez's company to go ahead and file in the federal courts because it might send Miss Kashina for a loop here. So let me take a sip. Oh, okay. Now I am going back into it. Rare Beauty is not aware of any instance of consumer confusion, basically saying that no one has confused Miss Kashina's brand with Selena Gomez's brand. And then they have peacefully coexisted since 2017. So they're basically saying that they're okay with them both operating under this business name. Kashina's not going to want to do that because with Selena Gomez's company being so big, they probably will take some customers from her, but not even notice it. But for Kashina, that would definitely hurt her because she is a small business. So if 2 or 3 of her customers are going over to Selena Gomez, then that's going to hurt her. But if 2 or 3 of Selena Gomez's customers are going over to Kashina, it's not really, they're not going to notice, honestly. So that's why they're saying they can coexist, but Kashina will not want them to coexist under the same name. Down to they do not directly compete with the Rare Beauty Cosmetics offerings. They're basically saying that they have different products and services than Miss Kashina has, so no one's going to confuse them. And they also said they target a separate and distinct customer base. Oh, excuse me. And they use different marketing channels. So they're basically saying they don't compete in commerce because they have different customers than Kashina might have. Okay, let me get it to. All right, sorry y'all, I'm over here choking. Just been talking too long. Okay, Adara says I would just let the name go and change it. I would too. It's no point of fighting this big of a company because they're going to have a bunch of money to fight with them. She's not going to have the money to fight with them. Yeah. Okay, let's pop back over here. Oh, I'm dying over here. All right. They don't infringe or dilute whatever common law rights that defendant might have. They were not deceptive in obtaining the trademark, and they were not fraudulent in obtaining the trademark. They were actually intending to use it, which they ended up showing proof to the USPTO that they are using it. So they're basically saying she doesn't have a claim to be asserting this. My bad, guys. I am not making it through this live stream. I have like 2 more cases to go, and I'm already choking. Hopefully, she can get Selena's customers. That would help her business. But I don't think she wants it because she might lose her customers to Selena. I'm gonna try to make it through this here. All right. So they're basically saying that they filed this lawsuit to prevent Kashina from filing a lawsuit because they have already offered her to buy her business out and help her come up with a new name to advertise her products through, and she denied them. They also offered to buy out all of her existing branded inventory. So she would have got paid for everything that she already has, and they would have helped her create another name, and they were going to pay her the value of her business. The issue with this is that they probably lowballed her, and Kashina didn't want to take it, or they potentially gave her the actual value of her business because, like, if nobody really knew about her and she wasn't making like $10K a month, they can easily say, hey, your business is worth $10,000. Let me help you make up a new name for your business. And she probably was like, no, that's not enough to let it go. I don't know where she's getting this $10 million from. I don't think she's lost $10 million worth of customers, but what she may be doing is saying that, Selena Gomez, you're actually infringing on my trademark. So you've probably made $10 million off of stealing my trademark. So give me all of the money that you have already made off of my trademark. So that may be the thing that she's going after, but I think it's going to be hard to prove that because I'm sure Selena Gomez did not know about her. And you do not need to know about the person to prove trademark infringement, especially when Kashina never registered her trademark. Selena Gomez is going to have a strong argument saying, like, she was not using this in commerce. I know this because I did not find her on the internet when I was searching the name. I didn't even find a website. So how could I have copied her? How could it be trademark infringement? She didn't have a trademark, basically, is what they can argue. And like I said, Selena Gomez can probably prove that she has priority in the name. And I don't know. Yep, I did not share my screen again. All right, get it back together. Ooh, I had a slip up there. Now I'm getting it back together here. Okay. So they're saying that they can reasonably believe that she will start litigation because she's asking for $10 million. She said, given the threats of Kashina, and they feel like they're entitled to a judicial declaration that there is no likelihood of confusion on one hand, and whatever rights that the defendant might own, and therefore Rare Beauty does not infringe any rights owned by the defendant. Rare Beauty is similarly entitled to declaration affirming the validity of Rare Beauty registration. So they're saying that everything that they've done it right. So they shouldn't lose their trademark just because the small business is coming up and saying that she should have rights to the name because she started using it before them. In my opinion, she was not properly searching her name, because if she was properly searching her name, she would have found Selena Gomez's company. If she was doing her business the right way, she would have just filed her trademark before Selena Gomez could have ever filed it. So I feel like I'm with Alpha. You snooze, you lose. And just the way that the argument that she has is just not how trademark law works. And so they're just talking about how they've built up goodwill and consumer recognition, so they shouldn't have to change their name. They're saying there's been no actual controversy that has arose, so there should be no finding of confusion, and that they didn't do anything deceptive to get the name. What they're asking for, prayer for relief. So mind you, if you guys were missing at the beginning when I started this stream, the owner of this Rare Beauty Cosmetics company is a small Black business. It's owned by a Black woman. And this is what Selena Gomez is asking for. They're asking for the court to enter a judgment declaring that Rare Beauty use of Rare Beauty trademark in connection with Rare Beauty goods and services does not violate the trademark statutes and does not constitute trademark infringement under the Lanham Act or common law of Illinois. They're also asking the court to enter a judgment declaring that the defendant has not suffered any harm and is not entitled to injunctive relief, damages, or any relief under. They're basically saying she should not get paid because we did not infringe on her, and we didn't steal any of her customers. That the court entered judgment declaring that Rare Beauty registration is valid and not be canceled in connection with the cancellation proceeding. They want the federal court to tell the USPTO that they should not cancel Rare Beauty's trademarks. And then they also want for the court to order their attorney's fees, costs, and expenses. So they want Kashina to pay for their attorney's costs and expenses because you started this mess. Now you have to clean it up. They're asking for the money back. So her LLC may start to be filing bankruptcy soon too, just like she did. That's not nice. I'm not laughing. But they're asking for Kashina to pay her attorney's fees, and I can guarantee you 9 times out of 10, Selena Gomez's attorney fees are a lot more expensive than whatever attorney fees that Miss Kashina has paid so far to her attorney, okay? And they're also asking that the court grant Rare Beauty any other remedies that may be applicable. So basically, if we didn't name a certain remedy, can y'all let us know what it is and give that to us too? So what do you guys think about them asking for Miss Kashina, the small business owner, to pay for Selena Gomez's, the celebrities' attorney fees? Do you think that she should have to pay their attorney fees? I don't know about that. That's kind of mean. Adara says, oh, wow, they tried to help her and she refused. I would have taken the deal. Right, because anything for her small business, probably anything would have been a lot more than she was already getting. I think I read in an article somewhere that she has 5 employees and she was making $30,000 a year. So even if Selena Gomez offered her $30,000, she should have just took it and came up with a different name. And Selena Gomez's company was going to help her develop a new brand. And so she probably could have gotten help in introduction into the cosmetics industry and backing, and potentially had an even bigger brand than doing this lawsuit with Selena Gomez. It could still potentially help her, like as far as it goes to like publicity to her company. And so when she changes her name later down the line, she might still have a little bit better publicity. But sorry guys, I don't got it together. Okay. She might have had a little bit, it would have been better for her just to take that and get some help with the industry and possibly just get, make her business better than what it was. And I'm not sure how she's operating her company, but a lot of people that are doing small businesses online are running it out of their homes, out of their garage. Selena Gomez could have put her on. So we'll see if she goes for it next time. She should. I think that she should have. Well, I don't know how much they offered. They could have lowballed her. They could have been like $5,000 and you get out of here. That would have been messy, but it probably, I don't know. I would have took the deal too. But then again, it depends on what the deal was. So I'm sure that will come out soon. I would have took the deal at this point and capitalized from it. Now might not get a second chance. Exactly. Now they're asking for her to pay their bills, her bills and their bills, basically. If she were to win, then she could ask for Selena Gomez's company to pay her bill. But given the facts of the situation and that leg she's trying to stand on with priority, she is not likely. I cannot see her winning priority in this case. I cannot see it. Hopefully she can prove me wrong if she can get her attorney's fees paid. But when you're going after celebrities, you better have some money in the bank to go after these celebrities. So, which one of our cases a little later on, he has money in the bank to go after the celebrity. But this case and the Chris Brown and Drake case, I'm not sure if they have the money in the bank to go after these celebrities, especially if they're talking about she filed for bankruptcy in 2020. I don't know if her finances got all back together in 2 years, or not even 2 years. So like what, a year and a half? And I'm sorry if I sound stuffy, y'all. I had a cough attack earlier. Yep, you agree with Alpha, and you think that they're being petty. I think they're seeking out their legal remedies in this situation. They're basically like, stop. I don't like that she's trying to use, oh, I'm a small black business. A celebrity is trying to drown out a small black business. Now Kim Kardashian, with that skin that she tried to pull on that other company that had Skin Plus or whatever it is trademark, they have the trademark first. So I would say Kim Kardashian was wrong for that, but this one is the other way around. The celebrity had the trademark first. Even if she wasn't a celebrity, and they trademarked this, she would be in the same situation. She would not be able just to win it because she started selling things in 2017, and the other company started their development later in 2017, which they say they actually started their development in 2016. So I don't see how she's going to win that one. So, all right. So we're going to hop into the other case because I don't see any more questions coming up. I didn't think that one would take that long. It was an interesting one. Trademark infringement is always super interesting. I actually wanted to look at something else on that case, but the complaint was enough for me. And I also had a cough attack, so that was not fun. All right, so let's get rid of Selena Gomez. We already got her out the way. And now we're going to hop over to Chris Brown. All right, because Chris Brown got a couple of lawsuits going on right now, too, because he has the lawsuit that I talked about last week for the SA, basically drugging that girl and or allegedly drugging the girl and taking advantage of her. And now he had this case from last year, October, for copyright infringement against a person filed a copyright infringement against Drake and Chris Brown's song No Guidance. Have you guys ever heard of the song No Guidance? I know it's pretty popular, so I'm sure you guys heard it. No Guidance. It came out in, I think it says like 2019. Chris Brown and Drake are like, I would say two of the most popular American artists that there are. So to say that they copied this song, I feel like it's hard to believe. Alpha, or no, Adair says Chris Brown needs an exorcism. He probably does. He's been famous since he was a kid. And I was watching something that said, like, when people get famous as a kid, it's hard for them to like grow up out of the age that they became famous in. And so I feel like that's where he's at. I feel like he got too big for his britches too young, and now he can't win at this point. Alpha says it was a hit. I know, I still be jamming to it, even though him and Drake are out here doing some crazy stuff, and we might have to cancel them like R. Kelly. I don't know. I don't know. They just keep doing crazy stuff. That was supposed to be them mending their beef for Chris and Chris Brown. I mean, Chris Brown and Drake. I didn't know they had beef, but I don't keep up. Now I'm keeping up with celebrities because of what I'm doing here on YouTube, just explaining the law. But I didn't know they had beef back then. Okay, so boom. We're just going to kind of quickly go over the complaint and then jump into the motion to dismiss because that was the latest news. All right, so this person, Mr. Brandon Cooper and Timothy Valentine, and their their incorporation filed this lawsuit against Drake and Chris Brown for their song No Guidance. These people had a song called I Love Your Dress, and they're saying that the chorus of Chris Brown and Drake's song is too similar to his. And so let me just pop over and see. Have y'all ever heard this song, I Love Your Dress? And he said the beef was for Drake and Chris Brown and due to Rihanna. Well, Rihanna's out here having babies with A$AP Rocky now, so they beef should be good by now. Have you guys ever heard the song I Love Your Dress? Yeah, I had never heard it before. If you guys have time to go look at it once we're done with this live stream, I highly recommend you go listen to it and let me know in the comments on this video after on the replay if you think that the song is similar. I don't think it is. The song is not very good in my opinion. And it definitely does not compete with Grammy Award winning artists and the hottest artists in America. I don't think they compete. I don't think they compare. Okay. So they go start off by saying Drake and Chris Brown are famous singer songwriters and producers. They had their song No Guidance in 2018. I kind of want to pop down. They're saying that non-expert listeners have said the song is confusingly similar and that music experts have said the song are similar. They go on to talk about all of the parties. So who Cooper is, he's a songwriter, producer. He made the song I Love Your Dress. Valentine is a drummer. He did the beat. They have a copyright in the song I Love Your Dress that was made in 2016. So they will have some priority over the song if it was similar. And then they talk about all the companies that they sued in association with Chris Brown. This is a federal case because it's copyright law. And all right, they said that Cooper wrote the song in 2016, and he's at least a few months starting on about July 7, 2016, he published it on SoundCloud. So he's saying this is how Chris Brown and Drake knew about this song because for some reason he thinks that Chris Brown and Drake are listening to SoundCloud. I've never logged onto SoundCloud a day in my life, so I don't know if Chris Brown and Drake are signing on to that. That doesn't make sense. Okay, whatever. Then he goes on. Did I highlight it? Okay, there we go. He went on to say that he talked to someone associated with Cash Money Records back in March 2019. So Mike T. He talked to Mike T from Cash Money Records. So he's saying that Drake and Chris Brown must have heard this song because I talked to Mike T from Cash Money Records who had nothing to do with the No Guidance song. Cash Money Records was not on it. And then he goes on to describe the similarity of the songs, saying that there's some high degree of combined similar features, including the hook of the lyrics and the primary scale degrees, distinctive sound effects, metronome, light, click, and vocal effects. I really want you guys to go and listen to this song and let me know if he sounds like Chris Brown or Drake. I'm laughing because I listened to the song yesterday and like this is what makes the complaint even worse for me. He's saying that in his song he goes, "It's the way you walk and how you carry yourself, girl. You work so hard, you don't need no help. You got it, you got it." Oh no, that's oh yeah. So that was the Love Your Dress song. And then No Guidance is no 9 to 5, put your work in, flaws and all, I love them all. You're perfect, baby girl, you got it, girl, you got it, girl. So he's saying that's similar. And he says that they also refer to him in the song because in No Guidance, they say, flew the coop at 17, no guidance. And then he says it relates to him because people often call him Coop. And please let me know, isn't a coupe a car? Or they're saying flew the coop in which way? I'm not sure. I don't know. I would think that they're talking about a car, but maybe they're not. But he's saying that they referred to him, Drake and Chris Brown referred to this man that nobody knows in their song because allegedly they stole the song from him. But to me, the songs sound nothing alike. And then he also said there was an online publication, and it was distributed through the personal connections of Mike T, ANAC Collective, Birdman, and others. Again, people who had nothing to do with this song. December 15, 2020, Cooper and SSE, through their counsel, notified defendant that they were copying them. And then they went on to say that Chris Brown and Drake's team just basically ignored them and kept playing the song. Because, guys, again, I cannot stress this enough. If you listen to the song, you will hear no similarities. Let me not say no similarities. I did not hear any similarities. But again, I'm not a music expert, so they might be a little bit more savvy than I am in copyright infringement, Mr. Cooper. And so they're basically asking for any money made directly from the song, any money made indirectly from the song. Then they want 50% of the profits from now on. They want 50% of indirect profits and royalties. They also want formal recognition and acknowledgement of Cooper as the co-author of the song. Because they think that, again, they copied his song, I Love Your Dress. All right. And so basically the things that they're asking for or the things that they are alleging is copyright infringement under the common law. They're also saying copyright infringement under the statutory law here. They're also claiming vicarious copyright infringement. Why are they saying vicarious? Basically that they did it through the people that sung the song, I guess through Chris Brown and Drake. They're asking for a declaratory judgment, which is a remedy and not a cause of action. So that's interesting. And they're demanding for accounting, again, a remedy, not a cause of action. And they're saying that they were unjustly enriched by stealing the song. So they basically made money off of the I Love Your Dress song. And it was unjust because that money should have been going to Mr. Cooper, I guess, at least 50% of the song. Because the I got it, you got it, that was the main part of the song. He said that it was like in commercials and stuff like that. But I don't watch TV like that, so I don't know if it was in any commercials. Oh, you guys couldn't even see the complaint. I was highlighting stuff and thought I was showing it to you. Uh-oh. Well, that's the gist of the complaint. So I'll pop back over for the other part of it. We have a direct say. I hope I'm saying your name right. I think some people sue saying their songs were stolen to get publicity. That is true because before the song, before this lawsuit, they didn't really have any views on YouTube. And then I just went and watched the video like yesterday or the day before, and they have like 200,000 views on the song, which is still not a lot, but probably a lot for this person. Like, I really want you to go watch the video after this. It's called I Love Your Dress by Mr. Cooper. I didn't listen to the whole song. I'm just going to say that. I didn't listen to the whole song because it was, It says a lot of times the songs sound nothing alike. Not at all. And with this one, which is we're going to get into in the motion to dismiss, is that the thing with this song is like the words are so generic. He's saying they copied him by saying, "You got it, girl, you got it," and he said, "You got it, you got it, she got it, she got it." So it's like that's a very common phrase and likely not copyrightable. So, and that's what Chris Brown and his people are going to argue. So let's pop bigger and go on over to the motion to dismiss. So this case it opened in October, and they basically been, I would call it effing around. They basically asked for like 3 or 4 extensions to respond to the complaint. So Drake and Chris Brown and all the other defendants, if you guys can see, let me go all the way back to the top. How many defendants they named in this? Like all of these people are defendants in this case. All of these people are defendants. That's a lot of people that they are claiming are defendants in the case. So just writers, production companies, all of that. They're trying to hold all of those people liable. So they sued all of these people, Mr. Cooper, Chris Brown Entertainment LLC, and Christopher Brown Entertainment LLC. Basically, Chris Brown's attorneys wrote up this motion to dismiss They have not written an answer to this complaint because they keep asking for extensions. And now they're to the point where they say, you know what, just dismiss the song because they don't have any standing to sue us for copyright infringement. And we're going to get into why they don't think that they have any standing. So this is the article, or not this is the article, but articles are basically citing this motion to dismiss, talking about Drake and Chris Brown said that Mr. Cooper has a baseless lawsuit. And so this is what is going to get into that. The motion to dismiss is what's saying it's a baseless lawsuit. So plaintiffs bring this baseless suit alleging defendants infringe the copyright of their song, I Love Your Dress. Plaintiffs speculate that defendant, who includes two of the biggest musical artists in the world, Brown and co-defendant Drake, access plaintiff's obscure song. They didn't have to call it obscure. Copy certain aspects of the songs and then promptly release a forged song. And mind you, he's saying that he released a song in 2016 on SoundCloud, then he turned around and took it off, and then he released it, or he performed it like July or so, 2019, and then Chris Brown and them came out with this song. I think he performed it like he said May or something, and then they came out with a song in June. So they're saying they promptly released the song based off of this obscure song. The No Guidance song, and it's an enormous commercial success, garnering more than 373 million views on YouTube and charting number 5 on the Billboard Hot 100 and earning Grammy nominations for Best R&B Song. The complaint must be dismissed as plaintiffs have not plausibly alleged copyright infringement, nor can they. As an initial matter, plaintiffs have not alleged that defendant had the requisite access to plaintiff's song. So Drake and Chris Brown had no idea that this song existed, is basically what they're saying. Either through widespread dissemination on the internet or through a third-party intermediary. So he's saying that he spoke with Mike T, so Mike T must have gave the song to Chris Brown. But he has no proof of that. He's not even alleging that in his complaint. And then also putting it on YouTube. As of right now, it has 200,000 views, and that is not really widespread dissemination, being that this case started in at the end of 2021. And I guess it's widespread because it's on YouTube and anyone can access it, but a lot of people haven't accessed it, is my point. Okay. They're basically claiming that the lyrics of You Got It are generic and unoriginal. And then the theme of a hardworking, attractive woman, again, is not copyrightable. And that's basically what this paragraph alleges. The court can hear for itself the total concept and feel of the song is vastly different. They say that the plaintiff's song, I Love Your Dress, is an R&B love ballad about the writer's wife, featuring one vocalist, which is Cooper. And so when you guys go and watch the video, it's literally a song to his wife, and like his wife is the love interest. I'm assuming the lady in the video is his wife, is his love interest in the video. And it's just a very awkward video, in my opinion. No Guidance is faster, longer, and sexually explicit rap and R&B song about a new romantic interest. Further, No Guidance features two vocalists, Chris Brown and Drake. Any average listener can readily distinguish the two recordings and conclude that defendant did not copy what is pleasing to the ears, as plaintiff is alleging in their lawsuit. So they're basically saying that they don't have enough to claim this copyright infringement. They go ahead and go through the parties. They go ahead and talk about how they didn't have access to the song. And in order to prove copyright infringement, you must have actually seen or heard or have some type of access to what you're actually copying. Because how could you copy something that you never seen, right? And so this is basically what this goes through. And this was filed by Chris Brown's attorneys, I believe. And basically what happened is that all the other defendants hopped on and said, yeah, we also agree with them. We join in the motion to dismiss. We also don't think that they have a claim. So they must have worked out something where his attorneys would respond, and then everybody else would just kind of piggyback on this motion to dismiss. And this is the argument. They're basically given the legal standards for a motion to dismiss, and they're saying that the plaintiff must do more than solely recite the elements of a violation and must plead facts with sufficient particularity so that his rights to relief are more than a mere conjecture. And then, so again, these are just the legal standards on why they should be able to dismiss the case before it actually goes to trial. They also cite the YouTube channels of which everything was posted. So we have the plaintiff, So I Love Your Dress, posted on YouTube on August 28th, 2018, and then on YouTube in May 17th, 2019. And then, my bad. I did not mean to do that. I didn't know it was clickable. Sorry, guys, if that was loud. It was loud on my end. Where did it go? This is not the complaint. Oh, I accidentally closed it. Let me stop sharing here so I can pull it back up. Sorry about that, guys. I messed this all up. Okay. Let me pop back over to you people. All right, so sorry about that. But in the case, it was something like Robin Thicke and Pharrell blurred lines. The song sounded exactly like Marvin Gaye's "Got to Give It Up." Yeah, so that one was super similar. The issue, so there are songs that sound similar, and you might hear them on the radio, but most of the time, people have the permission to use that song. So that's why they call it a sampled song. In that situation, they should have had permission to use that song before they did. And I didn't really look into that case. It could have been an instance of where they thought they had rights to the song, because a lot of times the actual owners of the songs are the studios and the production companies rather than the actual artists. But in that case, I believe they were saying that the estate of Marvin Gaye was actually the owner of the song. So that's why they could not use that song. So there are songs that do sound exactly the same, but most of the time they have permission to sample the song, just not in blurred lines. So I got my life back together on this song. So let me see if I can pull it back up for you, the peeps. Okay, here we go. Yeah, so I did not know these links were clickable. They uploaded their song Chris Brown on 2019 in June, and then again on July 26th of 2019. They basically say that they are failing to state a claim of copyright infringement. They don't own a valid copyright in the part of the song that they're saying they are infringing on. Again, saying you got it, you got it, you got it. I can almost guarantee that there are other songs that sound more similar to saying something about somebody has something than this song that the plaintiff is alleging. Again, they say that they didn't even access the song, so how could you say we copied you? And then we say there's no widespread dissemination of plaintiff songs. Basically, the song was not even popular enough for the song to even reach someone like Chris Brown and Drake and decide that they want to write a song on it. And they also made sure to mention that there were 5 other writers on the song, that there is no indication that any of them had access to the song to want to copy it. So I think that this dude is going to have a very hard time. And like, I get suing celebrities and getting publicity and all of that, but I don't get wanting to pay the celebrities' attorney's fees when you lose. Like, I wouldn't want to do that, because their attorney fees are going to be so high compared to yours, because they're going to have the best of the best lawyers that are charging, because they're working with Chris Brown and Drake. They're going to be charging thousands of dollars an hour versus a regular attorney that's trying to get their name out there, or a new attorney or whatever, what, $500 max an hour? Yeah. And they have like whole teams. So I can only imagine what Chris Brown and Drake's legal bill looked like. And not to mention that they also included all of these other people that I showed you guys earlier. All of these people. So imagine paying all of those defendant fees. All right. And so they're basically saying that they have not even given the correct, or they haven't even pled facts to prove that they could potentially be liable, so the case should just be dismissed. And then here they just compare the songs. This is the no guidance songs, which is a lot shorter than Mr. Cooper's song right here. It says, you got it, you got it, you got it, you got it. I love your dress, you got it, you got it, you got it, you got it. I love your dress, I love your dress. And yeah, I just want you guys to go watch the video, because the dress she had on, I don't know. That was not a dress I would make a song about, but that's his wife, so at least he loves his woman. They go on to say that the plaintiffs did not create the phrase "you got it," and then they go on to list several songs that also repeat the phrase "you got it" in it several times. So we have this song, "You Got It" by Roy Orbison. Don't know that song. Repeats it 17 times. Jodeci, "You Got," repeats it 22 times. Usher, "You Got It Bad." I feel like that song sounds more, I was looking at this yesterday, I feel like that song sounds more like No Guidance than this song that's alleging that it sounds like No Guidance. So, you got it bad. Oh yeah, I think that song sounds a lot more similar than this Mr. Cooper song. And then they also got "She Got It" by Two Pistols, and Ariana Grande's "Right There, You Got It" is repeated 7 times. So they went ahead and listed a bunch of songs that also use the same phrase, that he's not suing, but he's suing Chris Brown and Drake, and they're just saying those lyrics in particular are not copyrightable. So what are you talking about, Mr. Cooper? Get it together. They also talk about how the commonplace musical elements are not protectable. So like the rhythms, the melodies, and things like that are not protectable. And what else? I think they also talk about how like the talking to an attractive woman is not protectable. One of Chris Brown's like first songs, he's chasing after some girl down the street. So that is not a new theme. People are always chasing after some girl down the street in their music videos and R&B. So that theme is not new and is not copyrightable according to the defendants here. All right. So yeah, they're basically saying they failed to state a claim for accounting and that it's a remedy. And they actually didn't ask for anything. They just asked for them to dismiss the complaint. So they're not asking for him to pay for their fees in bringing this lawsuit. So hopefully he doesn't have to pay their fees, because it's going to be a very, very expensive. All right. So we have Adara saying Pharrell claimed it was totally original. What? Pharrell. I'm going to have to look at that case, because there's no way he thought that was original. I just listened to No Guidance and compared it to the other guy's song. There's no similarity other than "You Got It." And like the rhythm that he's saying "You Got It" in is not even the same rhythm that Chris Brown and Drake use in their song. The judge might be bust out laughing. Yeah, when I heard that song, like, I don't know if I'm hearing like a bad version of it, but it's like the beats did not even go together. So I was just confused. When I heard this song, I was like, what is this? This cannot be serious. Like, he cannot be serious talking about he's putting out music. There's no way that man is serious. Celebrities getting sued over foolishness. I agree with you there. So if you guys have not heard the song, I definitely would recommend going to listen to the song, get that man's views up, because he is going to need it at the end of this lawsuit. They actually didn't ask for money, didn't ask for attorney fees and costs or anything like that. They just said, dismiss this lawsuit. You're wasting our time. like Adara said, this is foolishness. Is basically what they should have wrote, but instead they gave them 21 pages of what they believe to be facts and what they believe to be not be trademark infringement. So, yeah, I think it was foolishness that they even filed this lawsuit. If you guys have not listened to the song, listen to the song and leave it in the comments. If you're watching this on the replay, leave it in the comments if you think that they are similar and if you think that Mr. Cooper has a case against Chris Brown and Drake and all those other defendants that they listed on this complaint. All right, so that was the end of that. We have Floyd Mayweather. Have you guys heard about the Floyd Mayweather's second case of the year? And it is currently February 8th, 2022. And Floyd Mayweather has been hit with 2 lawsuits within 3 weeks, if I'm counting that correctly. If you've been watching my channel for a little while, or even from the beginning of January, you know that Floyd Mayweather was sued alongside Kim Kardashian and that other basketball players that I cannot think of his name right now. They were sued for promoting a cryptocurrency scam for the Ethereum Max coin, saying that, oh, you'll make all this money if you buy into this Ethereum Max coin, which is basically a cryptocurrency. And they basically pumped it up and dumped it down. And so they were sued on January 7th of 2022 in the Superior Court of California. Now, Floyd Mayweather is being sued again, and I believe this one was filed on January 31st of 2022. So what is that, like 22 days later? They filed this lawsuit against him for breach of contract. So let's get into Floyd Mayweather and his new breach of contract lawsuit. So here we are. Well, no, we're not there yet. I think that's the Chris Brown lawsuit. Let me get over here. Okay. So I'm going to close this one out because we're done with him. And we have it here. Yogi Security Holdings, a limited liability company, a LLC in Nevada, is suing Floyd Mayweather and Mayweather Promotions, along with Mr. Al Heyman, who is Floyd Mayweather's right-hand man, and they're suing them in California, and it's for breach of contract, breaches of 2 contracts, breach of fiduciary duty, and breach of guarantee, conversion, negligent misrepresentation, fraud, and concealment. So they're being sued for 7 things at this point. Okay. So this complaint is pretty long. It gives a lot of facts. And so I am just going to go ahead and summarize it for you guys because it is a lot. So basically what happens is this Yogi Securities company went ahead and invested in Floyd Mayweather's fight that he had with Logan Paul. If you guys don't know who Floyd Mayweather is, he is a boxer, multi-champion. He's been doing it for a long time, and very popular, right? He got in a fight with this Logan Paul dude. They had a boxing match, Logan Paul, and Logan Paul is a YouTuber turned boxer, and he fought Floyd Mayweather in 2021 in June or July, which this boxing match was also brought up in Floyd Mayweather's cryptocurrency lawsuit. So I don't think this boxing match was a good move for Mr. Logan Paul because Floyd Mayweather is over here doing some crazy stuff. All right. So basically what happens, and I can't think of the dude's name. What's that guy's name? That is the main person in the lawsuit. He basically, I'm trying to find the guy's name. It's a kind of hard, it's not a common last name. They're going to bring him up a little later in the lawsuit because he wasn't named as an actual defendant. Englenoff. I think I'm saying that right. Okay, so what happened is that Floyd Mayweather got in the fight with Logan Paul. They did a big pay-per-view event promoted by Mayweather Productions and Floyd Mayweather. So they were putting on this fight where they were supposed to get money from, and you could have paid for your pay-per-view event or your tickets with the Ethereum Max coin because they were the only cryptocurrency accepted for that fight. Just the intertwinement between his two lawsuits. Thought that was pretty funny. But for this fight, Floyd Mayweather was fighting Logan Paul, and he asked for his friend, Mr. Inglenoff, I guess owner of the Yogi LLC, to go ahead and invest in his fight with him. The problem with this, Floyd Mayweather knew Mr. Inglenoff because they were friends for like 3 years. And Mr. Inglenoff was also friends with this Jonah defendant and this Mr. Robert defendant because they were all involved in the Jewish community. So he trusted Jonah and Robert in the investment idea that he was given to them. So he went ahead and invested $1.2 million into the ticket prices for the Mayweather and Logan Paul fight. And that was in June 2021, I believe. He was supposed to get paid sometime, I believe, in July. And time for payment came around, and he didn't get paid. And they told him he would get paid. And I think it was somewhere near $4 million. So he invested $1.2 million. They encouraged him to give another $200,000. So the first investment ended up being $1.4 million. And he was supposed to get a return, which included the $1.4 million was supposed to be paid first. And then I think 25% of any profits that were made off of the tickets. And it ended up being like $4 million altogether he was supposed to get back. But when the time came for him to be paid, they didn't pay him. And they kind of gave him the runaround. And then they said, you know what? We actually went and invested it in the next fight, which I believe that's the Pacquiao fight. And since I did that, then you're going to get more money. So I'm going to invest your money into this without telling you. But guess what? You're going to get more money back. Okay. So he went along with it because he trusted them, and they're a part of the Jewish community. So he trusted them. This section here is saying that they trust people in their community more than they would trust a normal person. So they went ahead and invested it, and they said, fine, it's okay. They didn't get the money back. They kind of just gave him the runaround. Second fight, same thing happened. He didn't get the money back. They told him they got the money. Then they said they didn't have the money, and it just went back and forth, right? And then you go on, and so they say, okay, well, we actually invested it into a third fight without your permission. But guess what? You're going to get all your money back, and you're going to be the first one to get paid. And Mr. Robert and Mr. Jonah personally guaranteed that they will pay for to make sure that this man gets his $5 million back now. Okay, they gave him the runaround. They never ended up giving this man his money back. So he is suing them for a breach of contract. And the reason why Floyd Mayweather is also involved in this lawsuit is because the initial negotiations, he allowed Mr. Jonah to have these conversations with Floyd Mayweather and Heyman, saying that they were going to get this money back and kind of backing the investment. So since they were investing in Mayweather production fights, and since they were investing in Floyd Mayweather's fight, this is why they're included in this. Again, there was 3 fights one fight that he invested in for $1.4 million. And then there were 2 additional fights that they invested his money into without giving him permission. The issue that I see with this case is like, why did he not get any of this stuff in writing? Like, I get trusting your friends and all of that good stuff, but this is $1.4 million. I don't know if I trust my friends that much to go ahead and do that. So let me know if you guys heard about this case. He went ahead and invested that money. And basically what's happening is that he's not getting his money back. And so the last fight was the Wilder fight for October 16th. they kept giving him the runaround, and he was like relying on the fact that they kept saying that they would pay him back, and that he trusted them because they were in the same community, that he didn't file the lawsuit. And so now he's actually filing the lawsuit because they haven't given him the money back. The issue, not the issue, but the funny thing about this case is that Jonah, one of the main players in this case, and Robert had actually been sued before for fraud. So get this, Englenoff knew that they had been sued before fraud, because Englenoff actually wrote a letter on Jonah's behalf trying to lighten Jonah's sentence. So Jonah went ahead and served his sentence, and then Mr. Englenoff gave Jonah a chance to kind of recover, allowed him to live in his house. Then Jonah stopped paying his rent. So that was already an issue. So Jonah had already stopped paying the rent, but you still decide to invest in a $1.4 million deal with Jonah and allow him to be your spokesperson. I really don't see how that makes any sense. And we have, I think it's just the Koofy. I don't know how to say that. What's up, Bri? Hello, welcome to the stream. We are an hour and a half in, so if you missed the live stream, go ahead and, watch the replay. But yeah, thank you for popping in. I am happy to see you here. I cannot pronounce your screen name, but I do recognize you, and I'm happy to see you here. We are just kind of talking about the Floyd Mayweather case, and it's a lot of like back and forth in that case. So that's why I don't kind of want to read it line for line like I had been doing, just because it's like a lot of confusion and names swapping, and I was confused reading it. So I hope I'm giving a good summary of what happened. But yeah, Jonah he already did fraud. Then his father is Robert, and Robert had also been sued for fraud already. And he had just had a bankruptcy proceeding. I cannot remember the exact year. It's somewhere in the complaint, but a bankruptcy proceeding where he recently told the bankruptcy court that he doesn't have any money. Yet he's promising Mr. Englenoff that he's going to pay him personally the $5 million if this deal falls in. But you just told the federal government or a court that you do not have any money to pay for the fraud that you already committed, because you are living on money from your nephews. So how are you going to pay Mr. Englenoff back? Okay, so that's the basis of the story. These people were like already fraudulent, so that's why I'm kind of like, I don't really feel bad for you, because you knew they were frauds, and you guys are in the same community, and so you should know that they're frauds. And you actually wrote a letter to help reduce the sentence of the fraud. So you can't even claim that you didn't know that they did. Not to say that that means he should have all his money taken, but it's kind of like you put yourself into that position. I gotta stop laughing at people. That's not nice. Okay. It's not nice. I'm not laughing at him, but basically Jonah paid him about $200,000 on one occasion and another $100,000 on another occasion, saying that he's making a good faith effort in front of the, I'm not Jewish, so I don't want to mess up the name, and I don't see it on my screen right now, but basically in front of under the Jewish religion, he's making a good faith offer to pay him $100,000 out of $5 million. Yeah, that's not that good faith, not that much of a good faith, right? So the first count is for the breach of contract for the Mayweather fight. And so this is against all of these defendants because they never paid him back from this fight, other than this little $200,000. So like, what is that going to do when it comes to $5 million? The interesting thing that I found about this case is, though, when they ask for this money, he's asking for $4.8 million off of the Mayweather and Logan Paul fight. And he's asking for all the money. And not only that, but he wants a constructive trust. So whatever money Floyd Mayweather, Al Heyman, Jonah, Robert, all these other people are getting paid, he wants all that money to go into his trust account. and for them to continue to pay him until his debt is paid off, saying that all of their money belongs to him now until he's paid off. Second cause of action was for the breach of contract of the Pacquiao fight, which he never received money for, in which he was supposed to get $5.856 million in total back, which would have included the initial $1.4 million. So this is not $4.8 million plus the $5.8 million. It's just the $5.8 million that he's asking for, that he was supposed to receive by September 9th, 2021, and he did not get it. Again, he is asking for that money to be put into a trust account. Third cause of action is a breach of fiduciary duty. Jonah was asking on his behalf, and all of these people were acting on his behalf to get his investments into these fights, and so that they should have been acting with his best interest in heart to go ahead and get his investments paid. And the issue that occurred is that there's a lot of emails and conversations back and forth of them all promising him that they will get him his money back. And then another thing in this case is they emphasize that the court needs to pierce the corporate veil of the LLCs that these people are operating under. So Floyd Mayweather Production LLC, they're saying that they basically went beyond the scope of the LLC, so they should not be protected under limited liability from being liable. So they want Floyd Mayweather to be liable personally, so himself as an individual and through his LLC, and then the same with all the other defendants. So he's trying to make sure he's going to get his money, because he's saying that these people were acting beyond the scope of their LLC, and so they should be held liable personally as well. And so they're basically saying they said they were going to give him the money. They never did. They invested his money without telling him, and he still never got his money. Fourth cause of action is a breach of guarantee. They all, not all, but several of the people guaranteed that they would make sure that he gets his money before everyone else is paid out. Or once they get their money, they'll give him his money. So he's saying that they didn't do that. Conversion. This occurs that he gave them $1.4 million to invest in the Logan Paul fight. He did that. They got whatever money that they made off the Logan Paul fight, which who knows if they made any money, because they were accepting Ethereum Max cryptocurrency, which value has dropped to way less than a penny. So maybe they didn't make any money. That's quite possible. That's the thing about cryptocurrency, though. So they took that money and they went ahead and invested it without his permission, which would be considered conversion. They took something without his permission and kept converting it into something else, which we don't know if they ever converted it, because who knows if they made money, especially if they were still accepting Ethereum Max coins. Negligent misrepresentation. They basically kept lying to him. And they might have thought they had grounds to say that they could pay him back, but it was still misrepresentation because they couldn't pay him back. And then also fraud and concealment. He's also saying that they knew and they intentionally told him that he would be paid back to prevent him from filing a lawsuit, with the knowledge that he could not be paid back with the amount of money that they made. And again, probably because they accepted Ethereum Max coins. I'm just going to keep tying the two lawsuits together. Because why would you? Floyd Mayweather, this is not a good look for you, buddy. Two lawsuits that has to do with you not giving people their money and taking money from nice consumers, your followers. In which I feel worse for the people that fell for the cryptocurrency scam, because more of them were likely regular people that could not afford to lose that money, where this guy had $1.4 million just to hand to them through a wire. So I don't feel that bad for him, especially because he knew that Mr. Robert and Mr. Jonah were fraud scam artists that they were alleged scam artists and they had been convicted of fraud. He knew that. So I don't feel that bad for Mr. Englenoff, if that's how you say his name. He is asking for a minimum or at least $15 million for the damages he was caused. Mind you, he is owed $5.8 million. And he is saying that they should be paying him $15 million due to all the inconsistencies and the punitives and all of those things. He wants his money to be put into a constructive trust and that they pay him before they pay anybody else. They also request for any other relief the court deems possible. So if he forgot to mention anything, then the court can also award those remedies as well. And a legal interest rate of 10% on any amount owed. So on top of the $5.8 million, he wants 10% of an interest rate added on that. From the date of the breach. So that could be accruing every day. I don't know exactly what that code is, but it'll probably give them an amount of time in which the 10% continues to accrue, and whether it's going to be like the whole amount or just from the amount that is owed. And I can't think of the word right now. So, and then they're also asking for punitive and exemplary damages to be determined by the court. Basically, he wants to punish them for what they did to him and also deter them from doing it again. So that is that case. So I don't know if anybody heard of that case. That one was a little bit more tricky because it was a lot of back and forth, and he said, she said, they said they were going to do this for me and they didn't do this for me. So it was definitely a case. I wanted to bring it up just because I covered the previous Floyd Mayweather case, and it's a little bit related to that case. And it's crazy to me that celebrities, they get rich from doing an activity, and then they kind of go down a rabbit hole of getting themselves in trouble when they're not having that consistent money coming in anymore, because Floyd Mayweather is retired. So he's trying to invest in different things, and it's turning out that the things that he is investing in, they keep turning out to be scams, or they're harming people financially, which is a white collar crime, but it's hurting people. Some people that cannot afford it, Mr. Englenoff probably could afford it, but there are people that were harmed in the cryptocurrency scam that probably couldn't afford to lose whatever money that they lost in that, which that was just cryptocurrency in general. It's a new thing, so it's kind of hard to know how it's going to affect people. But yeah, if you guys are watching this on the replay, please make sure that you go ahead and comment below what you thought of the cases, and catch me on the next live stream, or if you like to watch the replay, let me know your replay crew and that you'll be here on replay. Floyd may be getting taken advantage of. Do you think that he's getting taken advantage of by his right-hand man, or by just the people that are naming him in the lawsuit? Because they were, Floyd Mayweather was actually friends with this Englenoff guy, and Floyd Mayweather was in negotiations to buy Englenoff's home from him. So he knew him, and that's why he invested in the fight, along with persuasion by Mr. Jonah and Mr. Robert. So I don't know if he would be being taken advantage of in this sense, especially with the cryptocurrency case as well, because he was actually already sued for promoting a cryptocurrency scam, and he was not supposed to be doing any promotion of cryptocurrency for 3 years, and he violated that agreement or that judgment. Or was it? I think it was a settlement. He wasn't supposed to be doing that. So I don't know if he's being taken advantage of. We'll see how the case goes forward and what the defendants say, because this case was just filed on, when was this case filed? What is that? February 1st, 2022. So since it was just filed, we don't know what the defendants are saying. They have 30 days to respond. So by the end of the month, we should be hearing something on what the case, or what the defendants think about the case, and if they're going to move to dismiss it, if they're going to answer to it, if this thing is going to trial. But if he has 2 of these scamming fraud cases going on at once, I think it's going to be very interesting for him, and hopefully he can get out of it, or not get out of it, but the correct remedies are given. And if he's really not at fault in it, then that his liability be absolved. So that is all today. I want to thank everyone for joining the stream. This was a long one. I definitely appreciate the support. Like I said, I'm new at live streaming. All of this information given in this live was for informational purposes only. If you need actual legal help with your particular situation, make sure to consult with an attorney. I am an attorney, but I'm not your attorney unless you hire me. So I would definitely love to see everyone in the stream coming up in the future. I may stream again tomorrow, but I'll be on vacation this weekend. So I don't know if I'm going to stream tomorrow or I'm not streaming Thursday because I'll be in Mexico. But I don't know if I'll stream tomorrow. So you guys might have to catch me next week on the next stream. So yeah, definitely thank you for watching the stream, and I will see you next time.